Welcome back. This week we are talking about deterrence, corporate social responsibility, essentially doing the right thing. And starting off this week with this quote from the Peanut Corporation of America, one of the more famous prosecutions we've had in the past decade, maybe the past 20 or 30 years even. And this quote was from an email from one of the executives, I think from Parnell himself, saying that the delays were costing huge dollars. And ultimately, that's what we're talking about when we talk about this topic this week: corporate social responsibility, deterrence, money versus jail time or prosecution or other consequences from that. And so, in this backdrop, it's important to remember what we're talking about. And we are in food law and food regulation, and that has some unique statutory provisions. We'll talk about piercing the corporate veil. Normally, corporations are people, as Mitt Romney has said, and they have their own rights and they have their own ability. Typically, though, they act through agents. They do not physically reside or exist in some way. They have to act through us as humans. And normally, we have the ability to be behind that entity, to say, I am acting on behalf of, not acting personally. But in our food law and regulation system, we have the ability to say, no, someone needs to be responsible for the actions, and we're going to disregard that corporate entity and go after the executive, typically the executive themselves. Also unique in food, in particular on the FDA, which typically I would say has a broader mandate than the USDA FSIS, is extremely low barriers of entry. If I want to start a dietary supplement company, boom, I find a manufacturer, I find a label, find a product, I go forward. If I want to start selling a barbecue recipe that I created in my kitchen, again, food facility registration, and I'm on my way. And even some don't even go that far, simply just start selling. So extremely low barriers of entry, combining with unique statutory provisions, and that's the backdrop for this week as we talk about corporate social responsibility and deterrence. So what is corporate social responsibility or corporate responsibility? In regulatory circles, I would probably say it's more commonly referred to as the compliance culture. Not just for food companies, but for drug and medical device companies. Any FDA regulated or similarly regulated company like USDA FSIS would probably refer to it as compliance culture. What is your culture and reaction to things like expanding or initiating a recall, to understanding the regulations before you engage in operations? And this is a particular topic now as we talk about the FSMA. Do we just go forward and say FSMA doesn't apply to me, or I casually saw an exemption and yeah, that looked like me, I'm going to go for it? Or do we carefully read the regulations, put some resources into it, and understand them before we engage in our operations? And ultimately, and this is what we started the quote with, the huge dollars, this can mean at times we're protecting public health before profits. But again, it comes down to another way of saying this is doing the right thing. We can talk about it in terms of corporate responsibility, compliance culture, but ultimately we do not want to harm people just because we want to sell food. And I think that is the rub that we get down to, is that that's what we're talking about. We're protecting public health before profits. And it may mean that we have to put more resources towards compliance. If it's more testing, more swabbing, more personnel, we need to do PCQI training, whatever that may be. That may cost more in the quarter or in the year than what we're making, but we're ultimately trying to avoid getting people sick or hurting people. And maybe that other stuff, that economic harm, is secondary, but at least in the primary, we're talking about not hurting the public. And that should be at the forefront of what we're doing. The next question on corporate responsibility is, how do we, as the public, as consumers, measure compliance culture? We can't go into a food facility and look on the wall at reception and see, well, they have a 99.0 from their latest inspection, like we do in restaurants. I'm a big fan of seeing a restaurant have that right at the front of the restaurant. You can even see it from the window as you're passing by, and you can say, that's a 99, that's a 76, or whatever the difference may be. It gives you an insight, gives you an objective measure to say, what is this compliance culture? How serious are they taking hygiene in preparing food? And you can decide based on that whether you want to eat there or if there's a risk in eating there. We don't have something like that on the FDA or USDA FSI side. We can say warning letters to some extent. We could say if you're a really savvy consumer, you could file a Freedom of Information Act request and get a 483 and interpret that 483 to understand what those observations mean. But ultimately, there's nothing like that where we can just say, beyond the PR spin, beyond the websites, objectively, what is the compliance culture at a company? Regulatory agencies have their own ways of measuring that. And this is something where I feel frustrated. We have two different systems. So we have the USDA FSIS doing compulsory mandatory inspections every day. We have the FDA doing sporadic occasional inspections where the GMP, the good manufacturing practice violations that they're looking for, may be clues to broader issues. And I always tell my clients that the GMP observations are the tip of the iceberg. And the FDA is looking not only for how we respond to the 483 to get a sense of compliance culture, but also understanding of the GMP violation and whether that GMP violation points to broader issues. If it's a record-keeping issue, are all records missing? If it's a batch production sheet, does that mean that there hasn't been really a uniformity to how batches are made? All of these things can be indicators for the regulatory agencies coming into the facility when they do, at least on the FDA side, which may be very infrequently, to get a sense of that compliance culture. Now, the big juicy topic that we want to get into is deterrence. And deterrence is different than what we talked about last week with the ability to claim economic injury or even personal injury as a consumer and go to court and say, I suffered economic or personal injury and here are the damages from my lawsuit. It is a form of deterrence, but what I'm talking about this week and what we want to focus on is more narrow, more specific. We really want to talk about this form of strict liability that's unique to food law and that criminal penalty that goes with it. No one wants to go to jail, and that's the deterrence we're talking about. We want to avoid those jail penalties, those misdemeanor or felony penalties that stick with us and include, either fines or jail time. That's deterrence. It's a little bit different on the USDA FSIS side. We're talking about having to go through a process to open a plant, and that's a privilege. It can be granted or denied in that process, and when it's granted, you're bringing in FSIS personnel, and that privilege can be revoked, and you can lose your business. So in one way, that's an aspect that we don't have on the FDA directly. We do have now the suspension of food facility registrations, which is comparable in a way, but still a little bit different in the terms of deterrence that we're talking about. Typically, when we're talking about deterrence, we're talking about two things. The misdemeanor for anyone to deny an inspection, at least for a U.S. person. If it's a foreign corporation, we're not going to be talking about deterrence. We're going to be talking about import bar and not being able to bring your product into the U.S. But for a U.S. entity to deny an inspection, that's a misdemeanor. More commonly, we're talking about the Park Doctrine, that personal liability, that disregarding of the corporate entity, and the criminal liability under the Food, Drug, and Cosmetic Act, which is, again, a form of strict liability that we have. Now, what's unique about this is not every violation leads to a Department of Justice, FDA partnership leading to prosecution. There is this prosecutorial discretion deciding what cases go to court, what cases are worth pursuing, and which are not. And we can talk some this week about whether that's an area, an exposure for political influence, for social influence, or other influences to come in to influence someone in the Department of Justice to make a decision one way or the other. If there's a big social outcry that there must be justice, that could be influenced to say this case may ordinarily not have gone through the process for selection to be selected, but that outcry led to it being the case. And maybe we can talk about that in the case of Peanut Corporation of America, PCA. Was there a social influence that led to that? And conversely, we can talk about political influence. If you're a big corporation, as we've been talking about, you may have ability to influence senators or congresspeople, and that can lead to influence on the Department of Justice to pursue or not pursue a case. And so that's an area which seems innocuous in a way, but is an exposure for those influences we've been talking about. So there's actually a lot of depth to this deterrence. It's not just that it's strict liability, and if you mess up, whether you know about it or not, as we go through the Park Doctrine, all that criteria, you're gonna face criminal penalties. It's not that simple. It's strict liability, but it's also about fair warning. I can't be prosecuted for a crime I didn't know was a crime. So, for example, if all of a sudden the law changed and tying your shoelaces is now a misdemeanor, and I didn't know that, and a police officer sees me tying my shoes and tries to arrest me, I don't have fair warning that this law has changed and now this is a crime. It's an extreme example, it's an odd example, but it gives you a sense to say, constitutionally, I need fair warning of what is a crime so that I can be aware before I commit it, or have that mens rea, that intention to commit the crime, to do that. So that's what we're talking about here with fair warning. We also have the Regulatory Procedures Manual, which sets out 7 criteria for whether the FDA should dedicate resources, dedicate time to pursuing a case. And we have that on the screen. And you can see that the 7th criteria is whether the proposed prosecution is a prudent use of agency resources. All of this criteria is fairly objective. Violation is serious, widespread illegal behavior prior to warnings. If there's a warning letter or something else, pretty objective. But we get to that 7th criteria, prudent use of agency resources. That comes back to the prosecutorial discretion, comes back to this area of influence, either social or political, and it gives that hook to say, well, the 7th criteria isn't met, we're not going to go forward. And as we have in the reading materials this week, since about 2013, there have been 6 large-scale outbreaks which would be suitable for this criteria, for strict liability, fair warning, and applying this criteria that would have been suitable for prosecution, but not all 6 went to prosecution, only 3. So it gives you a sense that where the influencers are coming from, what the influencers are doing, and how those play into deterrence here. So deterrence is its own influence, but as we've seen throughout the course, there's difficulty in getting an influence to stand on its own. There's always overlays and cross influence from these different types of topics we're talking about, if it's economic influence, social influence, political, or this form of deterrence in the statute. So we'll continue this discussion in the discussion board this week. We'll look at the readings, and we have a very interesting discussion board topic to kind of encapsulate all of that we've been talking about this week. And I look forward to seeing your comments there.